All right, let's talk about law exams. You know, those case study questions. They land on your desk, full of facts, asking you to sort out some messy legal problem.
Yeah, they can be pretty daunting, especially when it's not just a straightforward breach, but something, well, something that goes deeper, undermining the whole contract. Yeah. A vitiating factor.
Exactly. It looks like a contract, maybe offer, acceptance, consideration are all there.
But then you dig a bit and you find something that makes it shaky, you know,
Hmm.
voidable. Maybe duress, maybe a mistake, or, and this is what we're diving into today, misrepresentation.
Misrepresentation.
Right.
Someone was led astray by what the other party said. That's our focus. And look, our goal here isn't just to explain the theory.
Right.
We want to give you a practical method, a step-by-step way to actually tackle case study questions on this, using the materials you've got there.
And these materials are great for that. They lay out the law, sure, but they also give you a clear structure, using a sample case to show how it works.
That sample case, Mr. Tan buying the car from Mrs. Lee. We'll keep coming back to that one. It's, a pretty standard scenario, perfect for seeing this stuff in action.
Okay, so let's jump into that structure the materials suggest. First things first, when you get any legal problem question, step one, identify the issue.
What's the actual legal question you need to answer based on those facts?
For misrepresentation cases, it usually boils down to, was there an actionable misrepresentation? And if yes, what can the misled party actually do about it?
So you're asking, did it happen legally? What kind was it? And what are the potential outcomes, the remedies?
Precisely. So applying that straight away to our car example, the issue is, did Miss Lee make statements about that car, its condition, that count as an actionable misrepresentation?
Right, giving Mr. Tan a legal basis to maybe get his money back or claim damages for repairs, something like that.
Exactly.
Okay, so you've pinned down the question. Step 2 is state the rule. You need to lay out the relevant law. And the materials start with the definition. What is misrepresentation legally?
Fundamentally, it's an untrue statement, a false statement of fact, made by one party to the other before the contract is signed, which helps persuade or induce them into making the deal.
Okay, and crucially, it's distinct from a statement that actually becomes a term of the contract itself.
Absolutely key distinction. If it's a term and it's untrue, you sue for breach of contract. If it's not a term but it's untrue and led you into the contract, then you might be looking at misrepresentation.
Got it. So not every false statement counts. What makes it actionable? The materials list specific elements, right? They all have to be there. What's the very first hurdle?
It must be a statement of fact, not just someone's opinion, not sales puffery, best car ever,
Yeah.
and generally not a statement about what they intend to do in the future.
Okay, so opinions are out. Like that case, Bissett.
Yeah.
Something about sheep farming.
Yeah, Bissett and Wilkinson. The seller gave an opinion on how many sheep the land could support. It was just his honest belief, not stated as a hard fact. Same sort of idea, though different context, with Tan Chin Sang in Rafflestown Club, statements about future facilities or exclusivity weren't treated as guarantees of present fact.
So you've got to look closely at the words. Is it describing how things are right now or just a belief or a hope?
Exactly. Though, watch out for exceptions. Silence usually isn't misrepresentation, but the materials mention things like half-truths, saying something true but leaving out a crucial detail that changes the meaning.
Or if circumstances change after you make a statement but before the contract is signed, you might have a duty to correct it.
Right. Or in certain contracts like insurance, you have a duty of utmost good faith, meaning you have to disclose relevant facts. So silence can sometimes bite you.
Okay, so false statement of fact, check. What's next?
It needs to be addressed to the party who gets misled. And it has to be made before or at the time the contract is formed. It can't be something you heard afterwards or something said to someone else entirely.
Makes sense. Then there's inducement. The statement has to actually, play a part in convincing the person to sign up.
Yeah, this is crucial. And the materials clarify, pointing to cases like Panatron, it doesn't need to be the only reason, just a reason. It played a role in their decision.
So it had some impact.
But if the person wasn't actually influenced, maybe they already knew it was false, or they did their own checks and relied solely on those dues, then there's no inducement, like in Tai Kim Sam.
And linked to that is reliance. They have to have actually relied on the statement.
Yes. And interestingly, the materials mention Redgrave and Hurd, which says even if you had the chance to check if the statement was true, but you didn't bother, you might still be able to claim. You relied on what they told you.
So being a bit careless in checking doesn't automatically kill your claim if you genuinely relied on their false statement.
It seems that way, yes. Depends on the circumstances, of course.
Okay, false statement of fact, addressed to the party, induced them, they relied on it. Is there a final element?
Yes, it generally needs to have caused some kind of loss or disadvantage to the party who was misled. If a false statement ticked all the other boxes but caused zero harm, there's usually nothing to sue over.
Right, so assuming you've got all those elements, an actionable misrepresentation did happen. The next big step, according to the guide, is figuring out the type of misrepresentation. Why does that matter so much?
Because the type determines the remedies available, and the law splits them into three main kinds, based mostly on the state of mind of the person making the statement.
Okay, let's start with the most serious one. Fraudulent misrepresentation.
This is where the person making the statement knew it was false, or didn't believe it was true, or was just reckless, completely careless about whether it was true or not. The classic definition comes from Darien Peak. The key is dishonesty, a lack of genuine belief in the statement's truth. Panatron is also cited as an example here.
So basically, they lied or didn't care if they were lying. Got it. What's the next level down?
Negligent misrepresentation. This is different. There's no intention to deceive, but the statement is made carelessly, without reasonable grounds for believing it's true. Section 2, subsection 1 of the Misrepresentation Act is really important here.
And the case example in the materials? Howard Marine.
Perfect example.
Yeah.
They gave some figures based on memory or dodgy documents when the correct information was right there in the ship's official papers. They didn't check properly. The court said, look, you didn't have reasonable grounds to believe those figures were accurate when you failed to check the easily available correct source.
So it's about carelessness in making the statement, especially if you seem like you know what you're talking about.
Pretty much, yes. It implies a lack of due care.
Okay. And the third type?
Innocent misrepresentation. This is where the statement turns out to be false, but the person who made it genuinely believed it was true, and, crucially, they did have reasonable grounds for that belief. It was an honest mistake, essentially.
Okay, so we've got fraudulent, dishonest, negligent, careless, no reasonable grounds, and innocent, honest mistake, but with reasonable grounds. Once you figure out which box it fits into, what happens next?
You said the contract is voidable.
Yes, voidable. That means the misled party has the choice. They can choose to rescind the contract, which basically means unwinding it, canceling it, trying to put everyone back where they were before the deal was made. Status quo ante, as the lawyers say.
Right, go back to square one. And the remedies that go along with rescission, or maybe instead of it, depend on the type.
Exactly. For fraudulent misrep, you can rescind and claim damages in the tort of deceit. These damages aim to compensate for all the losses flowing from the fraud, trying to put you back as if the misrepresentation never happened.
What about negligent misrepresentation under the Act, Section 2.1?
There, you can also seek rescission, or the court might award damages instead of rescission under Section 2.2. But importantly, you can claim damages under Section 2.1 itself.
And how are those damages calculated? This is interesting. The materials highlight, and the Roy Scott Trust case confirmed, that damages under Section 2.1 for negligent misrep are assessed as if it were fraudulent. So they can be quite extensive, covering direct losses even if they weren't foreseeable.
Wow, okay, so Section 2.1 is pretty powerful for the claimant. And what about poor old innocent misrepresentation?
For innocent misrep, the main remedy used to be just rescission. But Section 2 of the Act now gives the court discretion to award damages in lieu of rescission here too. If rescission isn't ordered, the claimant might also get an indemnity.
Indemnity. The materials define that as covering costs you are obliged to incur because you entered the contract, right? Not compensating for the lost value of the bargain, but just covering direct expenses from the deal itself.
That's the idea, restoring you financially to your pre-contract position regarding those specific obligations. And yeah, in lieu of just means instead of.
The materials also touch on the interplay between the Misrepresentation Act and the common law. It's not like the Act just replaced everything.
No, exactly. The Act builds on the common law. Fraudulent misrep is still largely dealt with under the common law tort of deceit. Negligent misrep can sometimes be claimed under common law too, based on Headley-Byrne, but it requires proving a duty of care, which can be tricky. Section 2.1 of the Act often provides an easier route.
Because the burden shifts.
Right. Under Section 2.1, once a misrepresentation causing loss is shown, the burden is on the person who made the statement to prove they had reasonable grounds to believe it was true. And Section 2.2 added that power for courts to award damages instead of rescission for negligent and innocent misrep, which wasn't available at common law for innocent misrep.
So courts often consider both avenues.
Uh-huh.
And one last thing on the rules, even if you prove misrepresentation, you might not be able to rescind the contract. There are bars to rescission.
Yes, definitely. The right to rescind can be lost. The main ways are if you affirm the contract after you know the truth, like carrying on with it regardless, if too much time passes, lapse of time, if it's become impossible to put both parties back in their original positions, or if a court decides under Section 2.2 to award damages instead.
Okay, that's a pretty solid rundown of the rules.
Mm.
Yep. Now for the crunch part. Step 3, application. Taking all that law and actually applying it to the facts of the Mr. Tan Pesces Lee car saga, this is where you show your work, really.
This is absolutely where the marks are. Let's walk through it. Ms. Lee's statements. Excellent condition, no mechanical issues whatsoever, engine and transmission are perfect, runs like new.
Yeah.
Are these statements a fact?
Well, based on the analysis in the guide, yeah. They sound like specific claims about the car's current state, not just vague opinions or future hopes like in Tan Chin Seng. More concrete.
Okay. Were they false?
Seems undeniable. The mechanic found major, long-standing transmission problems that directly contradicts perfect and no mechanical issues. So yes, false.
Addressed to Mr. Tan.
Yep. In the ad he saw and directly in conversation. Check.
Okay, now, inducement and reliance. Did her statements persuade him, and did he rely on them?
The facts say he was worried about exactly those things, engine and transmission, and asked specifically. He then relied on her assurances to go ahead and pay the $30,000. So her statements clearly played a part, like in Panatron. He didn't just buy it as seen.
Sounds like inducement and reliance are covered. And did he suffer loss?
Yes, the $8,000 repair bill, plus the car just isn't worth what he paid because of the fault, so loss is there too. It looks like all the elements for an actionable misrepresentation are met.
Right. So now, the crucial part. What type of misrepresentation is it? This really hinges on Mrs. Lee's state of mind, especially regarding that check engine light she kept seeing.
Could it be fraudulent? The guide suggests probably not. She seems to have genuinely believed the car was okay, maybe dismissing the light. To be fraudulent under Derry v. Peak, she'd need to know it was false or be reckless about the truth.
Reckless is the gray area, but her believing it was perfect, even if wrongly, probably pulls it away from outright fraud. Though you could argue ignoring a warning light is reckless. It's arguable.
What about innocent misrepresentation then? Could she say she honestly believed it was fine and maybe argue she had reasonable grounds? Perhaps she hadn't had trouble before the light or thought it was minor?
That's possible to argue. But this is where Section 2.1 and the idea of reasonable grounds becomes really important, pushing it towards negligent misrepresentation.
Because even if she believed it was true, did she have reasonable grounds for that belief when there was a recurring check engine light?
Exactly. That light is a big red flag, or amber anyway, making absolute statements like, perfect, no issues whatsoever, without checking out that warning light or at least mentioning it when asked about mechanical condition. That looks very much like making a statement without reasonable grounds. Remember Howard Marine, failing to check available info.
Yeah, it feels similar. She had information available, the light suggesting her belief might be wrong, but she made the strong statements anyway. Plus, the mechanic saying the issues were long-standing makes it harder for her to claim she had reasonable grounds to think everything was perfect.
And under Section 2.1, the burden's on her to prove she had those reasonable grounds. Given the check engine light, that's a tough ask.
So all things considered, the analysis points most strongly towards negligent misrepresentation under Section 2.1 of the Act.
Seems the most probable finding on these facts. So, based on that classification, what remedies would likely be available to Mr. Tan?
Okay, negligent misrep means the contract is voidable. So rescission is on the table, give the car back, get the $30,000 back.
Right.
Plus, he can claim damages under Section 2.1, and those damages are assessed like fraud damages according to Roy Scott Trust. So they could cover the $8,000 repair cost, maybe the difference in value, basically putting him back where he would have been if the misrepresentation hadn't happened.
And don't forget Section 2.2, the court could award damages instead of rescission if rescission seems unfair for some reason.
True, though. Are there any bars to rescission here? It's only been a week. He hasn't affirmed the contract by, say, using the car extensively knowing the fault. Getting the car and money back seems possible?
Doesn't seem like the main bar's affirmation, lapse of time, impossibility applies strongly here. So rescission looks like a real possibility, unless the court uses its Section 2.2 discretion. You'd mentioned those bars briefly in an answer.
Okay, great. So we've identified the issue, stated the rule, and thoroughly applied it to the facts, weighing the different types. Which brings us to the final step in the structure. Step 4, the conclusion.
Yep, just need to wrap it up clearly, summarize your analysis.
So for Mr. Tan, you'd conclude that, yes, it's highly likely an actionable misrepresentation occurred.
And based on the facts, particularly the check engine light versus Mrs. Lee's strong statements, the most probable type is negligent misrepresentation under Section 2(1).
And therefore, Mr. Tan likely has remedies available, primarily rescission and/or damages under Section 2.1, or potentially damages in lieu under Section 2.2.
Exactly. Issue, rule, application, conclusion. IRAC. That's the framework the materials provide, and it's your roadmap for tackling these problems systematically.
And I think the real key takeaway from walking through this is seeing that just knowing the definitions of fraudulent, negligent, innocent isn't enough.
Absolutely not.
The skill is in the application. Taking those messy facts, Mrs. Lee, Mr. Tan, the car, the check engine light, and carefully mapping them onto the legal rules. Using the cases and the act to argue why her statement was fact, why it induced him, and crucially, why her actions make it lean towards negligent rather than innocent or fraudulent.
It's about building that logical, supported argument, showing your reasoning step by step. And honestly, the best way to get good at it is just practice.
Yeah, take this Mr. Tan case study. What if, like you suggested earlier, Mrs. Lee had gone to a mechanic about the light, but the mechanic messed up and told her it was nothing?
How does that affect whether she had reasonable grounds for her belief when she spoke to Mr. Tan? See, changing one fact can shift the whole analysis. It forces you to think critically about the rules.
That's the process. Use this IRS structure, practice applying it to different scenarios, and you'll start to see how to break down even complex misrepresentation problems.
It really is a tool to cut through the complexity and build a clear answer.
Happy studying. Until the next class.